Welcome to News Desk. My name is Trix Ingado. Let's get you all caught up on the events of the day so far. And we start with the judiciary. Now, the Supreme Court has dismissed a petition to have Justice Smokin Wanjala, Njoki Ndungu and Mohammed Ibrahim recuse themselves from the BBI case. The petition was filed by Isaac Alwatch, who is in his application argued that the three judges were biased and partial. The Apex Court's decision, read by the Deputy CJ Philomela Mwilu, dismissed the application as having no merit. BBI appeal filed by Attorney General Kihara Kariuki at the Supreme Court will be heard between January the 8th and January the 20th, 2020.
It's allowed. The applicants will have 15 days within which to file their written submissions and list of authorities. And similarly, the respondents will have 15 days within which to respond. And in the event that the appellants would like to file a response, they will still have 5 days to file the response. As regards the second request, that instead of filing 15 pages of written submissions, Senior Counsel Mr. Oralo, who was supported by Senior Counsel Honorable Martha Karua and Mr. Watch, asked for 30 pages, while Mr. Avi asked for 40 days. The direction we gave was pursuant to the Supreme Court directions contained under Rule 17, which gives directions on written submissions in the following manner. A, written submissions shall be in the following form. A, contained in one volume only, whose length shall be as follows. In appeals arising from the Court of Appeal decision, submissions shall not exceed 15 pages. And in matters where the Supreme Court has original jurisdiction, the submissions shall not exceed 30 pages. We have, however, considered that request against the context that the appeal before us is complex. It raises weighty issues which have generated immense public interest. We have also considered originally this petition was filed in the Supreme Court, but it was referred to the High Court and has now found its way to this court.
All right, our reporter Murimi Mwangi is following the proceedings at the Supreme Court for us and now joins us with an update from the City Center studios. Murimi, very important proceedings going on right there. Could you put the issues into context for us?
Well, it was very important tricks for the Supreme Court to give these directions because it sets the stage for the full hearing, and particularly on that application that had been put in for the three judges to recuse themselves. It was critical that the bench dispenses or deals with that matter as a priority before the rest of the applications, because it would have had its repercussions on the quorum question, because had the three judges recused themselves from the bench, you'd have 4 judges left, which would be 1 judge short of the mandatory quorum of 5. So it was very important that that was the priority application before the rest of the directions were given. And of course, in these directions, 7 issues were picked for determination, most critical among them being the question of applicability of what they called the basic structure doctrine of the Constitution, which was the main foundation upon which at the appellate court there were arguments about the scope of how the structure of the Constitution can be altered in a case of attempted amendment. There's also the question of if a sitting president can institute an attempt or a constitutional amendment push by a popular initiative that was quite an emotive issue at the High Court and at the Court of Appeal, and the AG is seeking to overturn the position of the appellate court that barred a sitting president from instituting a constitutional amendment through a popular initiative. There's, of course, the whole question of public participation, which is also very critical to the IEBC, which is one of the appellants, on the scope of how that is supposed to be undertaken before the bill is approved for debate in the county assemblies, as well as the National Assembly and the Senate. But most importantly, and perhaps what most of the parties there were awaiting, was a determination on when the court would be sitting to hear the appeals. And of course, the court said January 18th, 19th, and 20th, when the parties will be heard. And that, of course, is an indication that the subsequent judgment will be expected sometime next year. Serious political repercussions, because that then goes to inform the key 2022 political players on if they can revive that process before the upcoming elections, or if, depending on the findings of the bench, there can be a future attempt to amend the Constitution, and what parameters would inform such a constitutional amendment push. Tricks.
Thank you very much. That is Murimi Mwangi giving us the latest concerning those proceedings. Now let's move on to politics. And Deputy President William Ruto today starts his 3-day tour of Nyanza region, just 2 weeks after Raila Odinga's visit to Kisumu.